Did you know that one of the earliest disputes you are likely to encounter in a medical malpractice case is not going to be with the opposing lawyer, the lawyer who represents the doctor you sue? Instead, it's probably going to be with the expert that you hire. You want to know what this is all about? Come join me for a walk around the lake as I share with you exactly what this means. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You believe that your doctor was careless and caused you significant harm and injury. Now, you go to an attorney to see whether or not you have a valid case. You believe in your heart of hearts that you know something was done wrong. You know and you believe that something slipped through the cracks, that your doctor was careless, and you know for sure that you suffered permanent injury, disabling injuries, injuries that are going to affect you for the rest of your life. Now, before your attorney can go ahead and actually start a case, your attorney is obligated to go ahead and obtain all of your medical records so that not only can he review all those medical records, but to hire the best medical expert he can find to confirm that yes, your doctor violated the basic standards of medical care, and yes, as a result of that wrongdoing, you suffered harm and injury. So here's what happens. Your attorney obtains all of your medical records, he reviews all the records, he then hires the best medical expert he can, and about a month or two down the road, the medical expert will call your attorney to tell him what he had to say, to tell him what he thinks, what are his opinions, what are his conclusions. And after that, your attorney will pick up the phone and call you and tell you what the expert had to say. The very first encounter you are likely to experience, a dispute, is likely going to be with the medical expert. Now, why is that? It's because the medical expert may not agree with you and your assessment of your case. The medical expert might determine that your doctor was simply not careless, that he did not violate the standard of care, that there were no departures from the standard of care, and therefore you have no basis for a case. And you turn around and tell your attorney, what are you talking about? I know I have a good case. I want to go ahead and start a case. The problem is you can't. Because in New York, we are required to have a medical expert confirm that you have a valid basis for a case. If the medical expert says you don't have a case, that's it. You can't bring a case. Now, you might say, I want to go ahead and get a second expert. Well, that's a topic for a different video. And yes, it is possible to go ahead and get a second expert. What happens, though, if the expert comes back and says, you know what? You're right. The doctor did depart from the standard of care. However, those departures, those violations from the standard of care did not cause you harm and injury. And you say, that's impossible. How else could I have suffered all these injuries? You're saying, that's ridiculous. I know in my heart of hearts that I would not have had these injuries but for this doctor's actions or inactions. That's your second dispute. Now, in that instance, you still cannot go forward. Why? Because the expert is unable to confirm that the doctor was careless, and that his carelessness was a cause of your injury. It doesn't have to be the cause, it only has to be a cause. Okay, so again, we get into the topic of whether or not to hire a second expert, but I'll leave that for a different video. So now, what happens if the expert comes back and says, yes, your doctor was in fact careless, and his carelessness was a cause of your injury? Now, the next thing the expert has to evaluate is whether your injuries are significant and or permanent. If the expert comes back and says, you know what, your injuries are temporary, they are not permanent, they are not disabling. Now, your attorney tells you this and you say, that's impossible. I haven't been able to go back to work. I haven't been able to do the activities that I used to do. I'm limited from doing so many things, all because this doctor was careless and caused me harm and injury. That's your next dispute that you are likely to encounter if the expert has come back and says your damages, your injuries are not as bad as you claim them to be. So getting back to the title of this video, it is possible that the earliest dispute you are going to encounter in your lawsuit, where you go ahead and want to sue the doctor who treated you, is not going to be from the defense attorney, it's not going to be from the doctor, but rather it could very well be from the expert that you hire. Now, you might be thinking, okay, then let's get a hired gun. Let's get somebody who's going to say that the doctor screwed up regardless of what's in the records. Well, I will tell you right now, that is a terrible, terrible idea. Why is that? It's because your attorney needs to know right at the front what the good things are about your case, where's the liability, where's the causation, where the damages, as well as where are the pitfalls. Every single case has pitfalls. And you may not think so because you, as the injured patient, believe that everything is in your favor, that had everything been done correctly, there is no possible way you would have suffered all of these injuries. The reality may be totally different. The reality may be that you had other comorbid conditions, meaning you had other problems, medical issues that caused and contributed to your injuries. And that if the doctor was in fact negligent, if he was careless, that certainly contributed, but it did not cause and was not the sole cause of your injury. So just because you believe in your heart of hearts that your doctor was careless and caused you harm and injury, does not necessarily mean that a qualified medical expert is going to agree with your assessment. In that instance, you are now going to have a conflict. And then you and your attorney are going to have a conversation about what to do next. Do you get another expert? Or does the attorney say, I'm sorry, I can't help you. You need to go to another attorney to see if you have the ability to get another evaluation. Why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases in the state of New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.